The way I feel for you, I had to sing a song of all the things I knew. My love is deeper than the holler, stronger than the river, higher than the pine trees growing tall upon the hill. My love is purer than the snowflakes all in late December, longest as a robin on the springtime windowsill, longer than the song of a whippoorwill. Back roads to the Broadway shows, there's 1,000,000 miles between, at least 1,000,000 love songs the people love to sing, and everyone's different, and everyone's the same. It's just another way of saying the same thing. My love is deeper than the holler, stronger than the river, higher than the pine trees growing tall upon the hill. My love is and the snowflakes that fall in late December, longest as a robin on the springtime windowsill, longer than the song of a whippoorwill. My love is deeper than the hollow, stronger than the river, higher than the pine trees growing tall upon the hill. My love is purer than the snowflakes all in late December, as honest as a robin on a springtime windowsill, longer than the song of a whippoorwill.
So, why don't you like flow? We have been in your high school. Why? But why? Why don't we actually do any work?
Well, that song was not planned, but anyway, I hope y'all enjoyed it. I got wide varieties of different types of music. I do play music on the side too. Let's get right into this. Let's listen to it, or as much as we can of it. It's late, I know. So here you go.
You're being asked to participate in this set of procedures, and you actually don't know what the procedures are and the reasons for them.
I think it felt fair, by the way. It felt much better than actual trials.
This is Briefly. This episode is part of a 3-part series looking at Title IX and the due process rights of students. This issue has attracted a lot of controversy recently when Secretary of Education Betsy DeVos rescinded the Obama administration's 2011 guidance for how universities should handle sexual misconduct cases. We've interviewed multiple professors to discuss this issue. This is part 1. Here we will look into the background of the 2011 Dear Colleague letter and talk with professors who have been involved with Title IX proceedings on their campuses. First, some background. The source of the controversy is a Dear Colleague letter that the Department of Education's Office of Civil Rights issued in 2011.
The Dear Colleague letter is a letter from Education Department officials at their Office of Civil Rights to their colleagues at federally funded educational institutions across the country, setting forth the OCR, the Office of Civil Rights' interpretation of Title IX.
That's Professor Daniel Hemmel, Assistant Professor of Law at the University of Chicago Law School.
So if you're a federally funded educational institution, you really don't want to violate Title IX. but the text of Title IX is pretty short and sweet. So you can't discriminate against or exclude from participation individuals in federally funded educational institutions on the basis of sex. And that leads to interpretive ambiguities, and the Dear Colleague letter was an attempt to resolve some of those ambiguities.
Specifically, the Dear Colleague letter offered guidance on how universities and colleges should handle sexual misconduct claims on their campuses. Certain parts of the guidance have proven controversial. For example, the Dear Colleague letter required universities to adopt the preponderance of the evidence standard of proof rather than the higher, clear and convincing evidence standard.
As for the force of law, or as for what legal effect it has, not much. If you're in the office of general counsel at a university, you'll read it. But a violation of the Dear Colleague letter is not itself grounds for revocation of federal funding. And the Department of Education would have to go through a number of steps before revoking federal funding on the basis of a violation of the guidelines set forth in the Dear Colleague letter. So if, let's say, there were a university that used a clear and convincing evidence standard rather than a preponderance of the evidence standard in its campus sexual assault adjudications, OCR would, upon receipt of a complaint from a student, initially try to resolve the matter with the university informally, and then would go through an adjudicative process within the Department of Education that would ultimately be subject to judicial review before they would pull federal funding. And during that adjudicative process, the fact of violation of the Dear Colleague letter would not be sufficient grounds upon which to fine for OCR, to fine for the Department of Education. So there are some instances in which there are regulations where simply violating the regulation is enough to show liability. A good example is in the tax context. The IRS issues documents with the force and effect of law on a regular basis that have interest rates that you have to use for gift loans among family members. And if you violate the rate, the IRS does not have to prove in a proceeding that the rate was right. Whereas in a review proceeding here, the Department of Education would have to show that you violated some other legal source with the force and effect of law. So you did not have an equitable grievance resolution procedure. It would simply saying you had a clear and convincing rather than preponderance of the evidence standard would not be enough.
We also spoke with University of Chicago law professor Saul Levmore. Professor Levmore previously served as a faculty chair on the university-wide Student Disciplinary Committee, which is the committee that oversees the University of Chicago's formal resolution process for handling Title IX complaints. Professor Levmore's comments are not a statement of official university policy. It is important to note that the University of Chicago's policy, like any university's, is not necessarily representative of Title IX policies elsewhere. The first step at the University of Chicago is for a student to bring his or her allegation to the Associate Dean of Students in the university. A preliminary investigation follows, which may include an in-person meeting during which the Associate Dean informs the student that they have been accused of sexual misconduct. After the investigation, the Associate Dean and a faculty chair of the university-wide Student Disciplinary Committee determine whether there is enough evidence to proceed to the formal resolution process.
Then he starts asking, he talks to somebody like me and says, well, this is what she says, this is what he says. What do you think? And I said, well, what was the impression you got of them? And, any other facts? Did you talk to anybody else? He goes, well, I was waiting for you. I did call the hospital to ask about this, and I found out that.
That's Professor Levmore.
And part of it is you don't have that much information until you actually go to the hearing. You have some information.
If formal resolution is warranted, the accuser will be asked to write a complaint, and the accused can offer a written response.
The material gets more and more formal, and now the guy builds up a dossier, and then that's one and then the committee is picked out of the people who have been trained and in the right categories. So now I'm going to go to this actual hearing. It's the first time I'm going to meet the people. and there's going to be 2 other faculty members and a staff member and a student. And then there's a whole procedure for how they sit in a room, and there's a little curtain between them. Have you run into this on TV or anything? So they don't have to look at each other.
During the hearing, the University of Chicago permits both students to bring exactly one support person with them. The support person is allowed to sit in and observe, but he or she is prohibited from being an active participant in the proceeding.
When we're there talking to them, we want to hear from the student, and we want the student to respond. We do the same thing, by the way, in cheating cases. It's just copying what universities have been doing for 100 years. We want to hear their version of how they took this exam or what they did or didn't borrow. And we don't want to hear some lawyer, give a twist. Of course, they could have talked to the lawyer and twisted their reactions. So we follow that. Again, it's not entirely realistic because they bend over and talk to their friend. Both sides do. They can write little notes to each other. The rule seems a little Mickey Mouse to me. But that's the rule, and that's very similar to the rule that we followed in other hearings.
Both parties have the opportunity to submit evidence during the hearing. With respect to cross-examination, the University of Chicago, for example, does not permit either student to directly question each other. Instead, they are permitted to submit questions to the faculty chair, who then determines whether the questions are appropriate to ask.
The questions had been asked 100 times, or they were irrelevant, or it just wasn't great. Once in a while they were good. Ask him about the time when, I think, I understand that one, but usually those things would have come up already. So I don't think it really would have been awful if they had asked each other questions. I don't know what you think about cross-examination in general, but...
The University of Chicago, there are 5 people who serve on the committee hearing a case. They consist of 3 faculty members, 1 staff member, and 1 student. At the conclusion of the hearing, the committee will determine whether the accused is responsible based on the preponderance of the evidence standard of proof. The university permits either student to appeal. Some professors have criticized universities for the way they handle sexual misconduct allegations. One such professor is Laura Kipnis, a communications professor at Northwestern University. In 2015, Northwestern investigated Professor Kipnis after graduate students filed Title IX complaints alleging that Kipnis had violated Northwestern's sexual misconduct policy.
I had written an article called Sexual Paranoia Strikes Academe for the Chronicle, and I had talked about the case of a professor on our campus, Peter Ludlow, a philosophy professor, who had gotten caught up in sexual misconduct allegations. And I had written a couple of paragraphs, and the students objected, I guess, to me, speaking about the case, and objected to the point of view that I took on it. And, one of the questions was why Northwestern would allow a case that had to do with a publication to go forward. So that became part of the discussion about it, whether that was a legitimate use of Title IX. And, I was found not culpable or not responsible. I can't remember the exact wording ultimately. But, after the school spent probably hundreds of thousands of dollars on bringing in these outside investigators and who produced 270-page reports and that sort of thing. So, yes, that has shaped my view of Title IX in the process. The procedures were very mysterious to me, starting with the fact that the investigators wouldn't tell me the actual complaints against me in writing. So they ended up flying to campus to meet with me and have an investigative meeting. But before that, we had a Skype session where they did tell me sort of the substance of the complaints, but they wouldn't put them in writing. So all of that stuff was kind of mysterious. Why wouldn't they put the complaints in writing? They wouldn't let me record the session. Why not? They themselves didn't record the session when we met. Somebody took notes, but then they allowed me to read a copy of the notes and make amendments if I wanted to. So you're being asked to participate in this set of procedures, and you actually don't know what the procedures are and the reasons for them.
In November of 2015, Northwestern philosophy professor Peter Ludlow resigned from Northwestern after being accused of sexual misconduct by 2 students,